It's public knowledge out there. My colleague Gaten Alfano was the attorney for the receiver that was appointed in the SEC litigation against par funding. He got attacked by the brother of the guy that founded par funding, but hid behind a bunch of aliases. What precipitated it was Gaten was trying to get this guy evicted from his brother's home, which was part of the receivership estate and had been recently sold at the direction of the court in order to help satisfy the $195 million judgment against his brother and sister-in-law and other principals of par funding. And yeah, he clocked him in an alleyway right in Center City, Philadelphia. And
this is like stuff you read, like there's shows about, like, but it really happened here in Philly where lawyers were cracking down on, I'll say, what sounds like a modern day loan shark operation, for lack of a better way of putting it.
Hey there, everyone. I'm Tom Bosworth, and this is the City of Brotherly Law. Welcome to Philly's Legal Pulse, where we chat with some of the city's and the country's best attorneys about what's really going on in our courts and our communities. Let's dive in and see what's brewing in the City of Brotherly Law.
Eric Lechtzin.
How you doing?
Good. How are you?
Good.
We've never met formally before, so I think it's always funny when lawyers meet, because as a lawyer, you always meet other lawyers on Zoom. It's like a regular part of being a lawyer, is not knowing anybody and then just jumping on a computer screen.
Yeah, that's kind of the way it goes these days.
Can you tell us what you do as a lawyer?
Sure. So I have a practice based in Newtown, Bucks County. We focus on doing class action and collective litigation. Our practice areas are centered on securities fraud, ERISA or employee benefits class actions, wage and hour class actions, and antitrust. And we do some data breach stuff for good measure.
I know what securities is only because I had to suffer through law school, but I feel like most people don't even know what that is and who you represent. But I mean, can you kind of like walk us through that?
Absolutely. So I actually got into the class action world through the securities fraud door. I was a defense attorney at a larger Philadelphia defense firm, and a guy that I worked with in a previous firm called me up one day and said, "Hey, Eric, do you want to work on the Enron securities fraud case?" And I said,
no big deal.
Yeah. And I said, his name is Sid. And I said, "Sid, ever since the news about that broke, I've been trying to figure out how I can get a piece of that action. So bring it on." And within a few weeks, I was down in Wilmington, Delaware, getting a crash course in securities fraud. And securities is a blanket term that describes investment vehicles like common stock, corporate bonds, unregistered securities such as limited partnership interests, which you see a lot in the real estate world, and even notes, notes of indebtedness. And in fact, one of my largest recent cases involved the sales of securities backed by notes that were in turn backed by cash advance loans to small businesses.
Is that a problem? Sounds like a problem.
It was a big problem, since the small businesses were not creditworthy enough to get loans from banks. So it was similar to a factoring arrangement where you pledge a portion of your receipts, and in exchange, the lender gives you money. Here they did it at the point of sale for a lot of merchants, like pizza places, stuff like that. And boom, right at the point of sale, you'd have 20-30% of your receipts scooped away by this company called Par Funding.
Oh, I know. I know about that case from and I'll just say this: there was because I don't know if you're allowed to or not. There was a lawyer who I actually know who was attacked in the street, violently attacked, and I think it's related to that case.
Yep.
Yeah, that's scary stuff. I mean, you don't usually see, civil litigation and violence kind of intersecting, but that happened, I think, right here in Philadelphia.
Yes, it did, and it's public knowledge out there.
Right.
My colleague Gaten Alfano, who was the attorney for the receiver that was appointed in the SEC litigation against Par Funding, he got attacked by the brother of the guy that founded Par Funding, but hid behind a bunch of aliases. And what precipitated it was Gaten was trying to get this guy evicted from his brother's home, which was part of the receivership estate and had been recently sold at the direction of the court in order to help satisfy the $195 million judgment against his brother and sister-in-law and other principals of Par Funding. And yeah, he clocked him in an alleyway right in Center City, Philadelphia. And
this is like stuff you read, like there's shows about, like, but it really happened here in Philly where lawyers were cracking down on I'll say what sounds like a modern day loan shark operation, for lack of a better way of putting it.
yeah,
and then a member then attacks a lawyer involved in that. I mean, it's like out of a storybook almost. Unfortunately, it happened.
yeah. Unfortunately, fortunately, Gaten is a real tough SOB, and he was back in action really pretty soon after that. I think they had to close his head with something like 8 staples or something. I don't know. He hit him with a big mag light.
What's a mag light?
The flashlights that
the heavy like steel flashlights
officers carry around on their belts. So a lot of heft to those things.
How does how has your job, where you're like looking behind the curtain of all sorts of corporate operations on behalf of people who have been harmed by various conduct of companies, how has your job, if at all, like kind of shaped your worldview or changed your worldview? Or maybe it hasn't. I don't know. I'm just always curious of that for people like you who are in that position.
Yeah. So I think one of the main ways that it's shaped my worldview is I'm very skeptical of just about everything I hear. And, sometimes I'll be just watching television with my wife or something, and we see a commercial for, I won't name drop, but we'll see a commercial for something, and I'll say, oh, what a crock. These guys are a bunch of liars. And she's like, why do you think that? I'm like, well, because that's pretty much my go-to. And
that's like your default. Your mind has been infected with like being saturated with all this stuff.
Yeah. And the Ponzi schemes like Par Funding is not the typical case that I handle, because in Ponzi schemes, typically there's nothing to recover because it's run by a fraudster whose only assets is the money that he stole from the victims of the Ponzi scheme. And usually the majority of that money is long gone. And, unless you have a big, deep pocket defendant to go after, like in the Madoff case, where you had investment banks that decided to invest their clients' money with Madoff, Or in the case of par funding, we sued the Eckert Siemens law firm, which was the advisor to a Better Financial Plan, which was the leading fundraiser for par funding.
I didn't know
So,
that.
yeah. So unless you have a deep pocket, you're going to have a heck of a time trying to get any money out of a Ponzi scheme.
Yeah. You know what got me about Bernie Madoff? I watched famous last words. I watched a documentary, but
There's some good ones.
well, no, but I really dug into it because I was like, when that all happened, I was like 19. I didn't know any. I mean, I didn't even know what. My dad was a cop. My mom waited tables, so I didn't know what investment. We didn't have any money. But I'm like, now I'm older and I'm a lawyer. I'm like, how the heck did this guy do this? Because the thing about Madoff, correct me if I'm wrong, is like he was someone who actually was like he was in circles with bona fide, legitimate investors for a very long time. I think like getting a lot of money and a charismatic, from all accounts, guy, talented, intelligent, but obviously, behind the scenes was this huge problem, huge problems. I guess it just made me think like, I think we inherently trust like the government and huge financial institutions to like wade through things that might be fake or but we're all, at the end of the day, we're all human, and this sort of thing can even happen for like even for a long amount of time. I don't know.
Yeah, no, what you're saying really resonates with me, because Madoff, he started out completely legit and well respected in Wall Street circles, and then he broke bad. And the way it happened with him, even though in his case it's on a scale that really has no parallel. The way it happened with him was at some point he wasn't able to deliver the returns that were being expected, and he had cash on hand, and he decided, okay, let me just hand out a little bit of this until things turn around, and then I'll make it back up and fix everything, and nobody will ever know. And that's maybe some
Snowball.
people get away with that kind of thing, but in the world I live in, that it rarely happens that way, because you start digging a hole and it just gets deeper.
Well, so you're somebody who represents people in class actions against companies for things like fraud, and I represent people who are physically hurt. And so like one of the things I wanted to ask you was like my clients know when they were hurt, like their leg was amputated or whatever. Like, do your clients, is there ever like an issue with them ever even finding out, like in cases like this, because you're dealing with like sometimes lots of people on a large scale where the individual financial harm to them might not raise your eyebrows, but when you add it all up, it's and isn't that part of the scheme too? Like, isn't that part of why and how the companies are able to get away with it? Because an individual person themselves might not sound an alarm. Like, do you know what I'm saying? I don't know if I'm asking.
Oh, yeah,
the right way,
totally. So, it really runs the spectrum from cases where it's obvious and just hits the investor in the face the morning they wake up. Like in the par funding Better Financial Plan case, all the investors were promised monthly payments of 10% or more of their investment, which, I mean, this was during the period of time when CDs were paying 1%, and even municipal bonds, if you could eke out 3%, that was a lot. So 10%.
So not a great time with respect to like the rates on those traditional types of investments.
Right. And the rates that a Better Financial Plan was promising, my clients told me, yeah, it kind of seemed too good to be true, but I did it and the checks kept coming every month. And they all knew that there was a problem when in 2000, I guess it was like March 2000, the checks stopped. And
Wait, that happened that long ago?
yeah, or 2020.
Okay, okay. I was like, ooh. But
I'm a
yeah,
little dyslexic, so
that's okay.
the numbers, I often say something that's not what I have pictured in my head.
All good. I was just like, I was gonna say that would have been a long time, but even I mean,
No, it was
they
2020, and they blamed it on COVID. Uh, our position was it's got nothing to do with COVID. This is your Ponzi scheme unraveling, as Ponzi schemes tend to do. But that was a case where it was very obvious to the investors. I just took a major hit, and I don't know what's next. And then you have, the typical securities fraud case where you're talking about publicly traded stocks. Usually there's some big news and the stock takes a nosedive. That's the typical scenario. And in our complaints, we have a section that the truth is disclosed, or the truth finally comes out. And that's where the market finds out why the representations of the company previously were false and misleading, and the market reacts to that by people selling off, and the price drops precipitously. But a lot of people, some people monitor their portfolios every day. Some people
never look at it. They just like, whatever. That's me, which is bad. I should probably call my financial advisor.
There's more than one school of thought on that. The Berkshire Hathaway approach is, buy stuff that you want to hold for the rest of your life, and don't worry about day-to-day vacillations, which is all well and good until something you invest in drops 20% in a single day. Then
yeah, you know what I was just thinking about when you were talking is like how my work, it can intersect with yours. And I'm just like shooting from the hip here, but I have cases right now against Monsanto, chemical company, which was purchased by Bayer, the giant chemical / pharmaceutical company in 2018. Bayer, a German company, bought Monsanto, which was headquartered in St. Louis, Missouri. And so I have clients who were harmed, specifically got cancer from being exposed to a toxic chemical called PCBs, which is short for polychlorinated biphenyls, which are horrific. Like even the United States banned them in 1979. So for something to be banned in the US, it takes,
those are the famous forever chemicals, right?
Exactly. And I grew up in a small town in Massachusetts where General Electric Company had a flagship facility there, and they polluted the river with PCBs. They dumped them like millions of pounds and dumped them actually in an elementary school playground where kids then played in the soil. And then I have kids who have cancer from the elementary school. It's this huge ongoing thing. But I remember, and the reason I'm bringing it up with you is I was reading the, I'm going to say it wrong, but it's like the annual report of Bayer. I guess they do an annual report to shareholders.
Yeah, that's the exact right term for it.
Okay. And Monsanto manufactured PCBs. They created them, right? So that's their child, so to speak. And I'm sure you deal with this too. So when Bayer bought Monsanto, I think I would be correct in saying they had an obligation on behalf of their shareholders to do a due diligence and investigate the company to make sure, like, what are the risks, what are the liabilities, what are the positives. And when you read Bayer's annual report, PCB shows up about 50 times. And basically what they all say every time when it comes up is because they've now been hit with verdicts in Washington state. They like billions of dollars of judgments against them for various exposure, because PCB is a pervasive thing throughout the world. Excuse me. But you look at Bayer's report and then they're like, we were aware of the PCB problem when we bought Monsanto, because a lot of the judgments didn't happen until after they bought Monsanto. But they're basically covering their butts. They're like, they're writing in there like, it's like this quasi hybrid of we weren't aware, but we were, but we weren't, but we were, but maybe but everything's okay and it's going to be fine and we're going to appeal and there's no risk and we correctly identified the risk. So do you see that?
All the time. And I was waiting for you to say the words, threatened litigation, ongoing litigation that could be material to the company's financial results. Yeah, I see those types of statements all the time, and the doublespeak is absolutely maddening. You can be sure that they did extensive pre-deal due diligence to find out, what's out there and what can we expect in ongoing and future litigation. And the reality is the true answer, you can't predict. You guys could have multi-billion-dollar verdicts, or maybe you'll get lucky somehow and not have to pay so much. But that's there's a lot of different types of securities fraud. We have the GAAP violation cases, generally accepted accounting principle cases.
What does that mean?
Where that's where a company fudges the numbers, and sometimes you'll hear about companies that have two sets of books, the one set that's correct and accurate and the other set that is for public consumption. Totally illegal. But there's all sorts of things. There's revenue recognition schemes. That's what you had in Enron, where you had round trip transactions where, $50 million would start out here with Enron and then go through a whole slew of different entities and end up back at Enron, and it had no economic substance whatsoever.
But, so it wasn't actually being used or given for anything real. It was just being moved.
Yeah, it was just being round tripped through a dozen entities. And when it came back to its original source, Enron, they recognized that money as revenue. Well, if you take $10,000 from your checking account and then you put it in your Vanguard account and then you move it to your Wells Fargo account and then you move it back to your checking account, you haven't earned any money.
I see. Okay. So
so one of the types of that we see. And another type is failing to disclose significant liabilities. And that can be everything from we're under government investigation for doing any number of things. Like, for example, sometimes you see Medicare fraud in companies that have Medicare as part of their business. You can see failing to disclose environmental issues. But hiding the truth is a type of fraud.
So they say.
Yeah.
What are, you must see some of like the same defenses recycled over and over again when a company hides the truth or fails to disclose, or maybe it depends.
Absolutely. You see the same stuff again and again. One of the main things that we have to contend with is the Private Securities Litigation Reform Act of 1995, or PSLRA, and that sets a very high bar for pleading. So, Rule 9 of the Federal Rules of Civil Procedure requires you to plead fraud with specificity.
Specificity, yeah.
And the PSLRA juices that up and says, not only do you have to plead fraud with specificity, but you have to plead scienter, or the state of
Mindset.
mind, yeah, with specificity, which is a real challenge because, knowing what's in people's minds is, other than your own, is a very, very difficult and generally speculative matter, and usually has to be established by indirect means. So, for example, if you have an insider who dumps 10 million worth of company stock right before the bad news comes out, well, you can infer from that they probably had
some information.
They knew what the real deal was, and they've tried to avoid a loss.
Inside baseball.
Yeah, exactly. But in the world of cases where people have no idea of that they've been injured, I see that all the time as well.
So how do they end up with you? Like, how does that happen?
Well, so let me give you a couple examples from the ERISA world, the employee benefits world. So when somebody loses their job, or they get divorced and they lose their employer-sponsored health coverage, they're entitled to receive a notice under a part of ERISA called COBRA. And a COBRA notice is supposed to tell you exactly what you have to do to continue your benefits and how much it's going to cost you. And I just settled a class action for 184 people who didn't receive notices, or received notices that were defective. And one guy realized, hey, my rights have been infringed, and we brought the class action on.
But they sent the same type of notice to everybody.
Yeah. So his notice came something like 287 days late.
Wow.
And the expression "better late than never" is not accurate when it comes to your health insurance.
Exactly. Right. I was going to say,
because that's the kind of thing that you might need any day of the week, and if you don't have it, you're in a tight spot. So and when you get a late notice, yes, you can activate your COBRA coverage, but you have to pay the premiums for the entire time from the qualifying event up to that day. So,
well, what I don't understand though is, like, because I know COBRA generally, like, but when you need COBRA, it's for a specific in between amount of time, usually, like you're in between jobs or in between insurance. So if that time frame has already come and gone, and then you're getting this notice, were they getting the coverage at the time, or am I asking?
Yeah. So usually there is a delay in the termination of the coverage. Most employers will pay for health insurance a month in advance for their employees. So, if you want to be really tight-fisted, you can call up the insurer and cancel the coverage the day of, but usually that doesn't happen. So, let's say you got terminated on the 15th of the month, your benefits don't end until 2 weeks later. Sometimes they continue even longer than that. So, people can be lulled into a false sense of security in that way. But COBRA usually will go for 18 months. So, for example, when I left my prior firm, I was a partner at Berger Montague, a large plaintiffs class action firm. And I was part of the Great Quit in May of 2020 during COVID.
I recall.
Decided to start up a new business with my partner, Mark Edelson.
Good for you. And I just partnered up with my best friend from law school, Terry D'Angelo. So
nice.
It's great. I love it. Like doing your own thing. You don't run out of headaches, but you're doing it. So.
Yeah, if I had known how much I'd like it, I would have done it 10 years earlier easily.
Sorry, I didn't mean to interrupt you, but
no, but so yeah, so Cobra goes for up to 18 months. And, when I started up my practice, yeah, I was gainfully self-employed, but I was able to get much better insurance than I could have for my new firm by just riding out Cobra from Big Papa Burger Montague. And so I used that for 18 months. And then when that ran out, my partner and I said, okay, now we've got to do this for real and set up a firm-wide plan. But
so is it just you two, or do you have other attorneys?
We have 5 full-time attorneys, and we usually have 3 or 4 contract attorneys working for us who, mainly they do document review type work. And for the antitrust cases, that's a big deal.
I clerked, my first job out of law school was a clerk for a federal district judge, and he sat by designation on the Third Circuit, which they sometimes will pluck a district court judge and let them sit by designation. And one of the most interesting cases I ever worked on was I shouldn't say the judge wrote a dissent in the Third Circuit.
We know how it works.
The judge wrote a dissent in the Third Circuit in an antitrust case. What was it called? It was a parallel price fixing case involving paint. And basically there was an antitrust claim brought against these different manufacturers of paint for price fixing, for and about like price signaling and basically jacking prices up at the same time to make money. And the district court had granted summary judgment in favor of the defendants, basically saying there's no issue of material fact here, case is dismissed.
Right.
And it was a circumstantial evidence case because you didn't necessarily have a smoking gun email from company A to company B saying, hey, let's on January 14th, let's raise the price of red paint to $7. Right. Mm-hmm. What you had was on January 14th, the 2 companies raised the price of paint to $7 the same time. And they had been at a freaking golf tournament the day before together and had a big meeting with all these other companies who also, by the way, raised the price of red paint to $7. And you had those meetings over and over and over and over again.
Coincidence, man.
And the judge dissented. The Third Circuit affirmed the grant of summary judgment. And I mean, I was fresh out of law school. I dug into this. I had to learn things about conscious parallelism and all these. Antitrust is it's like a different language. But the bottom line, I'm like, this is a factual question for the jury. Like this is like, it's circumstantial evidence, which is a fundamental tenet of the law where, you don't always have to prove it. You don't have to prove anything with direct evidence, but how much more circumstantial evidence do you need? We're not talking about whether they win the case. We're talking about whether they can make it the claim to the jury. And in my mind, that was a no-brainer. But I mean, I know you've seen, I'm sure so much depends on what judge you have, but it's to your point too about like mindset. How are you going to plead the mindset of a CEO? You're going to go talk to the CEO, So I don't know. I'm sure you see these issues all the time.
Yeah, absolutely. And you're bringing up 2 things that trend wise has been ongoing for literally decades. My practice has centered in the federal courts since 2020. And, the taking issues away from juries has been a persistent march of the federal courts. And that march has been led by the Supreme Court. And it's harder and harder to get a pleading past the motion to dismiss. It's harder and harder to get to trial. And, it's the culprits are the U.S. Chamber of Commerce and institutions like that think that anytime a company has to defend a lawsuit,
it's frivolous.
Yeah, it's frivolous and a crushing hardship for the company. And, we'd all be much better off if plaintiffs' attorneys were just put out of business.
Well, thankfully we're not, and thankfully you're not, and unfortunately we have to wrap up. But Eric Lechtzin, I greatly appreciate you coming on, and can you just tell the viewers if they needed to get a hold of you or where they can find you and how to get you?
Absolutely. So our website is edelson-law.com. We didn't put my name on that because it's got too many non-phonetic letters. And you can easily reach me. I actually answer my own phone, and our number is 215-867-2399. I even answer after hours, just not on Shabbat.
Amen. Well, thank you, Eric. Thank you so much for joining us, and that'll do it.
Thanks. And if you want to call me back and talk about ERISA, I'm happy to do it.
And that's a wrap for this episode of City of Brotherly Law. I'm Tom Bosworth, reminding you that in Philly, we don't just practice law, we live it, breathe it, we fight for it every day. This city was built on grit and determination. That's exactly how we approach justice. That's how we approach cases. Join us next time for more straight talk and legal insights from the heart of Philadelphia. Until then, stay tough and keep it real, Philly.